Right, so this is just going to be a short, maybe 5-minute video, just going through the basic things for intoxication. Although I know it's not one of your mock options, it's an area that generally students are not very confident with. So here we go then. Right, so in the top left hand corner I've put essay, problem, question and dilemma. So intoxication can be any part of this. So it was a test essay last year in the real paper. It can be part of a problem question, so you might have a murder problem, but somebody might also be intoxicated or self-defense intoxication, and of course it could be part of or an entire dilemma board. Really then, the aim of the video is not to sort of teach you the content. Really by now you should be confident with pretty much most of A2 law. This is just a quick sort of rerun of the basic things that need to be established, so that if it is part of a problem or dilemma, you should be able to use this to help. Right, so I've put number 1 there, vol involved. So really the key thing for intoxication is whether the drinking or drugs or anything really is voluntary or involuntary. So if we start with voluntary, then I've drawn the arrow down to basic and specific. So in a problem or dilemma, if that person voluntarily takes the drug or the drink, you need to see what sort of crime they've committed. So if they voluntarily do it and commit a basic crime, you see I've put there NA. So a basic crime is anything that its mens rea says intention or recklessness. It's that keyword recklessness. So if it's intention or subjective recklessness, that means that the defence will automatically fail. Why? Well, your leading case is the case of Majewski, and Majewski turned around and said that if you choose to drink, it is a reckless course of conduct. So because of that ruling, every case with voluntary intoxication will fail there as a result. So this one here, this is your key case there. I've also put a couple underneath just so, again, you're backing yourself up. Remember, you need a certain amount of cases here. If it is part of a problem question, you might not need as many, depending what else is there, but it's always good to back yourselves up. So you've got Majewski as your leading precedent. You've then got Richardson and Irwin. This one actually confirmed Majewski, but then sort of added a subjective test there as well. So rather than just saying you've drunk, you're reckless, guilty, Richardson says, well, yeah, you drunk, you're reckless, would you have seen the risk if sober? In which case, generally, yes. So you are always guilty, but it just makes it a bit fairer. And then you've got Heard. So the sexual assault one technically should have been a specific intent offence, but the judges obviously went with it to be basic in order then to protect society. So you've got 3 leading precedents there, all relevant for basic. So again, just to repeat, your basic rule: voluntarily get drunk and you commit a crime that's got recklessness as its mens rea, i.e. assault, battery, ABH, section 20 GBH, manslaughter, anything on that sort of role there, you will automatically be convicted. Intoxication will not work as a defence. If you voluntarily drink and commit a specific crime, then the only way that this will work as a defence is if you've got no mens rea. So I've put no MR there. So you have to prove to the court that you had no intention to do the offence, and that's when it will work. This is because specific crimes are crimes that require intention. So like murder, for example, requires your direct or oblique intention, or theft, you need the intention to permanently deprive. So offences that haven't got recklessness, i.e. they've just got MR, if you prove that you haven't got that MR, so therefore you wouldn't normally be convicted, intoxication will work, okay? However, you just need to make sure that you are aware it will only reduce the crime. Sorry, this pen's not working very well. It will only reduce it. It won't actually give you a full acquittal. So, i.e. murder would drop to manslaughter in that sense there. Okay, now your cases that you've got here then for your precedents, we've got Beard, Lippman, Sheehan and Moore and Gallagher. They're sort of your main ones. So Beard was probably the first proper case you did there, the rape and strangling of the 13-year-old, and Lord Birkenhead set that test that wasn't very good, but good judicial reasoning for you. And basically, yeah, so Bird's test, were you capable of forming MR? Not a very good test, so Sheehan changed it. Did you actually form the MR? So we've got to look there whether you got the mens rea or not. If you can successfully prove you didn't, it will work. So this case here, Lippman, this is where it worked. So he could prove he didn't have the mens rea to kill her, because it was during an hallucination and his MR was to sort of fight snakes. He got the defence and it dropped his murder charge to manslaughter, okay? Whereas extra case to use there would be Gallagher. Gallagher did have the MR to kill, and he actually had it before drinking, so if anything that made him even worse. And I've put at the side Dutch courage, so that's like an extra category really, that if you ever drink for Dutch courage it's never going to work because you've already got that prior intention. So if it's voluntary drinking, they're your basic rules, okay? If it's a basic crime, it will never work. If it's a specific crime, it will work, but it'll only reduce your charge. So just watch out for that in problems or dilemmas. If it's involuntary, then we're just looking at this bit up here. So if it's involuntary, it can work for basic or specific. It's a little bit more lenient, so you'd get a full acquittal rather than just having it reduced. But again, that test is the same. You've got to prove that you had no mens rea. If you've still got some form of MR, even though it might not have been your fault, it does not matter. Okay, so we've got 3 categories there: laced drinks, prescribed meds, and soporific. So if it's a laced drink, it's got to be a soft drink in order for you to get the defence. So if I go out tonight and get an apple juice and that gets spiked, and then I commit a crime, I will get the defence there, as long as I've got no MR, obviously. Alan then, so you've got the homebrew, that's just showing that strength's irrelevant. He chose to still drink it, knowing it's alcohol, so it's not classed as a laced drink. Prescribed medication, so if you've got a prescribed medication and it has an unpredictable effect, or something goes on that's not meant to, you can get it. Bailey tried, but it would been a diabetic for 30 years, remember, so it wasn't an unpredictable effect. And then the same sort of test for soporific drugs there. So Hardy had taken the Valium, it's meant to calm you down, it didn't calm him down, it rendered him aggressive, so he did get the defence, although arguably some judges thought he didn't deserve it. So to conclude on that point then, if it's involuntary, basically we just have to establish that you had no mens rea whatsoever, and as long as that's there, you will get the full acquittal. Okay, very lastly at the bottom then, intox and other. So when you mix intoxication with other defences, you've got different rules and regulations there. The main one is intoxication and mistake. So the minute you drink, if you make a mistake, tough, our law is very, very harsh. Okay, so although normally you'd think making a mistake could make you less liable, so they might reduce your charge, for example, they don't do that in this instance. Okay, if anything it makes you more guilty, so it's very harsh. It's a good AO2 point. So normally a mistake will never give you a defence, and we've got O'Grady and Hatton there, so you've seen these with self-defence as well. So in both cases they tried to argue self-defence, mistake and intoxication, but the minute you mix the drink there, it doesn't work for any basic or specific crimes, so it failed in those 2 cases. The exception to the rule though is section 5 of the Criminal Damage Act. If you can prove that you honestly believe the owner would consent to you committing criminal damage despite the fact you're intoxicated and it's a mistake, you will get the defence. So with Jagan and Dickinson there, although it wasn't her friend's window she smashed, it was another house, she honestly believed her friend would allow her to smash the window to get in, therefore she did get the defence there. But normally mistake will never ever provide a defence, so unless you see it maybe in a dilemma, it could be just they do a statement on that potentially, so then you'd go against and show me that it would work, or it might just be a general mistake dilemma board, in which case you're always going to say it fails, or again it could be part of a section B. Okay, so that was just a very quick rerun, just under 10 minutes there for your general rules for intoxication. So again, just to finalise, if it's voluntary drinking or drugs, look at the crime. If it's basic, it fails. If it's specific, it fails unless you can prove you've got no mens rea. If it's involuntary intoxication, as long as you've got no mens rea and you're not really at fault, any of the 3 categories would work. You've just got to prove the extra. So like with laced drinks, it must be soft, for example. And then finally, if it's intoxication and any other defence, and your biggest one here would be mistake, then it's never going to work unless it falls under section 5 of the Criminal Damage Act. Okay, so I've put most of your cases on there. There's enough there for you for if it was a test essay, so if they brought that up again in summer, for you to write about voluntary and involuntary intoxication, or if it's part of a problem question, just pick on what's relevant. So if it's basic, just use your basic cases, specific, just use your specific, and obviously dilemmas, you're just looking at what that statement asks you.